Welcome to Brady, a simple approach. I'm James McLaughlin, a retired chief, and currently serve as Executive Director and General Counsel of the Texas Police Chiefs Association. As law enforcement officers, we have a duty to protect and serve. We also have a duty to seek justice. In 1970, when I started in law enforcement and went through the academy, we heard about Miranda and several other cases, but a case named Brady versus Maryland was never discussed. In 1963, U.S. Supreme Court issued a landmark decision called Brady versus Maryland. It basically said at that time that the prosecution has a duty to disclose to the defense, when requested, of evidence they think might be helpful to the defense. Since 1963, there have been a number of additional cases that have further explained that duty of prosecutors. There will be more about those cases later. As many of you are aware, much media attention has recently been directed at allegations of misconduct by state actors in the investigation and prosecution of cases here in Texas. While many complaints have proven to be meritless, the fact remains that mistakes have been made and our system is in need of repair. This is not the fault of one actor or one group of actors. It is a system-wide problem that we can and will fix. And all of us should take great pride in the knowledge that Texas leads the nation in many of our reforms, particularly in the area of education and training of law enforcement. Other states and several federal organizations have recognized our progress and have asked us for our help in developing their own programs, using Texas as a model. This is yet another such venture that we have been told is the first of its kind in the nation. Today we concentrate only on training law enforcement, on the Bradys. Remember, you are only one integral part of the state's team, but please note, no one should point fingers in the direction of the other members of the state's team. And the other members are also subjected to the scrutiny of the courts in reviewing cases against Brady complaints. Just to give you a few real-life examples involving allegations of misconduct by other players in the system, there are hundreds of cases currently pending before the Texas Court of Criminal Appeals involving problem lab results which may or not have been disclosed. And the court has handled down many cases involving misconduct by prosecutors. In an aggravated sexual assault case, the state's knowledge of a police report relating to the victim's relationship with another adult together with the timing of the victim's intensive therapy was sufficient to alert the state that the testimony was misleading, and there was a reasonable likelihood that the false testimony resulted in a harsher punishment. There was also evidence that the false testimony affected the applicant's sentence relating to a second victim. Because the applicant showed that the state knowingly used false material testimony and he was unable to raise that claim at trial or on appeal, the court granted relief. It should be noted that this information was handed over to the district attorney by the police and was in the work product folder of the district attorney. Please note that similar education endeavors have been and continue to be at the forefront of education for judges, prosecutors, and defense attorneys. Today's presentation focuses on Brady versus Maryland, a United States Supreme Court case governing the disclosure of favorable evidence in criminal cases. Finally, we are here today in partnership with the Texas Court of Criminal Appeals and the State Bar of Texas to present this instructional video. They are producing and distributing this piece at their expense and have secured TCLOS credit for this one-hour presentation. The course number is 21000. I will now hand it over to Chief Mike Corley.
Welcome. My name is Mike Corley. I'm the Chief of Police in Brownwood, Texas. I'm not going to talk about the Brady Law today. I'm going to talk about a personal story. As I talk about this story, I ask that you keep an open mind about what you might do during an investigation and how this might apply to Brady today. I want to take you back to the year 1985. That's when all this happened. It's a story about a man who spent 23 years in prison for a crime he did not do. It's a story about a rape victim that was brutally raped at 19 years old. And it's a story of a young investigator learning as he goes. In 1985, I was a detective with the police department in Richardson, Texas. I was a pretty good detective, I thought. I was in the Crimes Against Persons unit, and I worked most of the big cases. One spring day in 1985, I got the call of a sexual assault in an apartment complex in Richardson. And it turned out it was a 19-year-old student, had gone to the bank. She was very happy, sold her car, got a ride back home to her apartment, came home, and unbeknownst to her, she had interrupted a burglar. She went inside the apartment. At first, she didn't know what was going on, but she noticed her stereo out of place, and eventually she saw the door had been jimmied. At that time, she was attacked, and I won't go into all the specific details, but she was sexually assaulted. She was beaten very badly. We had to take her to the hospital, of course, and it was a very traumatic experience for her, and it was a very long sexual assault. It took about 45 minutes or an hour. I got called to the scene. We went to the hospital like we always do and did the rape kit. And as I talked to Debbie, I won't mention her last name, but her name was Debbie, I did know one thing, that this was a very terrible crime and that she was a very smart, articulate victim. Even though she was 19 years old, she's very smart. To this day, right now, she's a legal aide at a very prestigious law firm in Dallas. Anyway, I was assigned the case. We didn't have any suspects. We did have a bit of a vehicle description. As a matter of fact, as this crime occurred, Debbie's boyfriend came over to visit her because they had a date to go to lunch. The window was open. It was in the spring, so it's kind of a warm day. And her boyfriend called into her. Well, Debbie's attacker had a knife to her throat and said, "If you tell him to come in, I will kill both of you." And so she did not say nothing, and her boyfriend left. And as we go on through the story, you'll see that Debbie is a very good witness, and I say this because it's not like a 7-Eleven robbery where the victim sees the suspect for about 15 seconds. Debbie told me later, she told me at the hospital, she said, Detective Corley, when he was assaulting me, we were nose to nose, he was right on top of her. He said, I was trying to remember his face. I wanted to put him in prison. I wanted to identify him. I wanted him to pay for what he had done. Later, somebody in the apartment complex, during this was all going on, saw what they thought was a suspect vehicle, and it turned out to be it was. It was a big 4-door vehicle. And later on in the investigation, I'll go back to Debbie. We left the hospital, and we did the rape kit. And everything was fine. She was very traumatized, but as far as evidence goes, we did exactly what we should have done. We took her clothes, we did the rape examination, and I thought everything was well in order. Well, it was the very next day, and I got a call from Dallas Police Department. If you don't know, Richardson is just on the northern edge of Dallas, and so we share a lot of crime and a lot of criminals. They had just made an arrest on very similar circumstances. It was not a sexual assault, but it was a burglary very similar to what we had. And it was just a day later, and it was literally across the street from where ours had occurred. Well, they had the suspects in a live lineup. I took Debbie there, and she looked at all of the suspects, and she said, Detective, the man that raped me is not there. And I felt confident in her non-identification, in her abilities, and I didn't think he was in that. And so that bolstered her credibility to me as a witness. Well, time went by, and we didn't have any suspects. And as it would happen, another investigator in Richardson, he came to me and he said, if you looked at Thomas McGowan as a suspect in your sexual assault. And I said no, and I knew Thomas just a little bit. He lived in Richardson, and he had been in his share of trouble before. And I said no. He said, well, Thomas fits the description of your suspect, and also he drives a large brown car. Did you know that? And I said no, I did not. And so I did not have a good picture of Thomas. We had a picture of him in jail, but I wanted a recent picture of him to use for a photo lineup. And I looked for Thomas. I went to his house, and he lived not 2 minutes from the police station. I talked to his mother. His mother said she had seen him, but he's not around right now. And I told him I just wanted to talk to him. I told the mother that. Well, the mother must have told Thomas that I was looking for him. He disappeared. So I spent a lot of time looking for Thomas, but if you've been in the Dallas area, it's like any big metropolitan area. there's a lot of ways to hide, and Thomas hid well, so I could not find him. So I had a decision to make, and I decided to go ahead and show Thomas's picture in the photo lineup from his jail picture. And I knew it wasn't the best picture. It wasn't that old. It was only a few months old, maybe a year. But I did not get to use the one that I would want to use several days after the offense had occurred. A couple other names had came up in the investigation, and I put their photos in there too. And just as an investigative matter, that's the way we did things back in 1985. I would not do that now. But I thought at the time, instead of having 6 pictures in there, if I had 7 pictures in there, that would make it that maybe having 2 suspects in there. So I gave a photo lineup to Debbie, and it had 7 pictures in there as opposed to 6. But it had 2 people in there that I thought were pretty good suspects, Thomas being one of them, and another person being the other. Debbie went right to Thomas's picture. She said, "I think that's the one." And I'm sure that's the one. I said, "Debbie, you have to be sure." And she said, Detective Corley, "I'm sure that this is the person." And I felt good with her identification. I was 100% convicted that it was good. At that time, I don't know, I've been a detective a few years, and I'd seen very many identifications, not 20 years worth, but I'd seen my share. And I knew she was a good witness, so I felt good about it. But I never, ever wanted to file a case just on a photo identification. So what I decided to do was, since I couldn't find Thomas, I got an arrest warrant for him, just an arrest warrant. I did not file a case with the DA's office. I just wanted to get Thomas, ask him where he was that day, and get his blood from him so we could do a test. And I would ask you to remember that back in 1985, there was no DNA. It was only blood typing, and that was the only way we could identify him. So 6 months went by. The warrant was, well, it wasn't 6 months. It was probably 2 or 3 months that went by. The warrant was on the computer. And I finally got a call from the Dallas Sheriff's Office that Thomas had been found by Dallas PD. Evidently, he had been hiding out in a low-rent motel, and they had been cruising through there and had some type of disturbance and found Thomas, and he had an arrest warrant. So the next day, I went down to the county jail and picked up Thomas. He's very angry man, and I asked him about where he was, and by now it's a couple of months after the offense had happened, so it was very tough to nail him down. And all he would tell me at that time was, I was with a prostitute that day. I said, okay. We took him to a lab, the forensic lab in Dallas County, Texas. Took his blood, and I took him back to the jail. And I still did not file my case with the DA's office. The reason being I wanted to wait for the lab results to see if his blood type matched the blood type that we found in the rape kit. Well, it didn't take long, and then the lab called me a couple of weeks later, and they said, "Detective Corley, I've got some bad news for you. Turns out that the sample we took during the rape examination of the bodily fluids, the seminal fluid, was not enough to get a blood type off of." And I was very disappointed in that, and I said, "Why didn't you tell me that in the first place?" And they said, "Well, we didn't know until we got it to the lab that there was not enough for typing." So at that point, I was stuck with that. So I had another decision to make. Do I file the case? Do I not file the case? I did not feel there was further evidence that we could find, and I felt we had our guy. I was 100% sure that we had the right guy. So, to make a long story short, we did file the case. I filed the case of burglary on Thomas McGowan, and it went to the DA's office. The DA's office in Dallas County, they saw the case. They liked the case enough that they added the sexual assault. So it went to the grand jury for burglary of a habitation and aggravated sexual assault. He was indicted on both. He pled not guilty. He pled not guilty to both of those. And we eventually ended up in trial on both charges. Debbie was a great witness. As you know, in Texas law, if we use a photo lineup, we have to go have a hearing before the trial. The judge looked at the photo lineup, said it was fine, he liked it, it was good, it would be admissible as evidence in court. Of course, the defense objected to it during trial, but it was overruled. During the trial, Debbie was a good witness. She made a good identification in court. She looked right at Thomas McGowan and said, "That's the man that raped me right there. That's the man that broke into my house right there." Very convincing. And in her mind, she was 100% sure that that's who it was. No question to her. No question to me either. And then on the first trial, Thomas, he was convicted, sentenced to life, and the DA's office offered him a deal on the second one, just plead out, Thomas, and we'll let it be time served with your other charge. He refused. He said, "I didn't do it." So we had a second trial. Pretty much the same thing happened as a different jury. It was several months later, but he was convicted again, and he was sentenced to life in prison again. And the judge thought it was pretty serious too. He stacked the charges, so he had a life sentence on top of a life sentence. So you know what that means. That means Thomas is not getting out of jail for the rest of his life. And I'll never forget, at the end of the second trial, we were waiting for the punishment phase. I was sitting close to Debbie, and Thomas was sitting in the defendant's chair, not about 15, 20 feet away, and he looked back and he looked at Debbie and he said, "I'm going to kill you, bitch." And he had a hatred look in his face. It concerned me enough that I got up and I got in between Debbie and him just in case he did make a bolt for her, but that never happened. But for myself and for Debbie both, if there was any doubt at all, which there wasn't, but that really sealed the deal. Why would he want to come back and kill her if he didn't do this thing? Okay, well, that should be the end of a very good, happy story, shouldn't it? But it's not. Thomas went to jail. He was a very angry man. He wrote me letters from prison. They weren't very nice. I did not share them with Debbie because I knew that she would freak out, and she was already concerned. As a matter of fact, she was so afraid of him getting out of prison, she called Texas Department of Corrections every 3 or 4 days to make sure he's still there. She ended up moving up to Virginia because she was afraid that he might get out. Well, like I said, that should be the end of a story. We have a bad criminal that's been brought to justice, and now he's in penitentiary. Well, that was 1985. We'll run it forward to 2008. And I'm sitting at my desk, and by this time I'm an assistant chief with the Richardson Police Department. Phone rings. It's the DA's office. Wow, I haven't filed a case in like 15 years. I don't know what you're calling me for. Do you remember the case of Thomas McGowan? I remember it very well. I still have the case file right here in my office. Well, Mr. McGowan has contacted the Innocence Project. They've looked at his case, and they want to do a DNA sample. They want to get the DNA from the DA's office. They still have it, by the way, and see if it's a match. I said, that's fine. I was 100%. I said, I will help whatever you need to accomplish this task. I'll be glad to help you with that. Because I knew in my heart of hearts that, and in my mind, in my logical mind, that Thomas McGowan was the one that assaulted Debbie. Well, we went through a process, which is another thing that I know we're talking about Brady here, but when you have an exoneration like this is going to be, the victim, our Debbie, went through it all over again. Just telling her that we were going to get a buccal swab from her, and we went up to this prestigious law firm to get it. You know, it was very embarrassing for her, and she was very worried. And we got a swab from, just the fact, we got a swab from Thomas McGowan, and just the fact that she knew that Thomas McGowan was coming up to Dallas County to get that swab made her very uncomfortable and very frightened. Well, we'll skip part of the story here and go on to what I know what you want to hear. Well, the results came back just a short time later, and they called me in the office, and I said, okay, and I was waiting for that answer, and they said that swab did not come back to Thomas McGowan. He is not the one that sexually assaulted. He did not leave that specimen in Debbie. And I felt like I was kicked in the stomach is how I felt. And it was the DNA evidence. And I know how important technology is. I know how important evidence is, especially DNA, and I had no question. The difficult task at that point was coming to grips with it myself, of course, and of course passing it on to Debbie. Debbie and I had a pretty good relationship even after 23 years. We still knew each other kind of like we did when she was the first victim. And I got to tell you, that's one of the hardest things I've ever had to do as a police officer was tell her that she identified the wrong person and that he has spent 23 years in jail for a crime that he did not commit. When we told Debbie, well, she said, well, Mike, I know that Thomas did it. There is a mistake. The lab technician, the lab itself, the machine, whatever, it made a mistake. It did not. And so it was not Thomas McGowan. And we found out later, and to cut the story a little bit shorter, we actually did find out who the real person was. It was not Thomas, but the irony that comes out is that I told you before that there was a second suspect that I could not get a hold of before. It was that person. The person that actually sexually assaulted Debbie was the one right next to him on that photo alignment. That's what happened. So Debbie got some closure in the fact that we did find the person. He was already in jail again on a federal charge. He's there right now. But he's on parole on a federal charge for a bank robbery that he committed in Richardson. And he will be getting out here in about 5 years. And the sad thing about that is we will not be able to charge him with the sexual assault of Debbie. And that's her crusade right now for the legislature and opening eyes as she talks to victims. Well, the story doesn't end there. We went on unbelievably. If you would have told me just 5-6 years ago that I would have arrested a guy that spent 23 years in prison for a crime that he didn't commit, I told you was crazy. I was a good detective. I don't do that. I'm a thorough, good investigator. And then if you would have told me that I was going to go meet him and see if he wanted to go on some speaking things with me, I would even told you were even crazier. Well, I was invited by the International Association of Chiefs of Police. They knew about this case, and they asked me to please check with Thomas and check with Debbie and see if we might want to give a presentation to the annual conference at IACP. That's a pretty daunting task. I thought about it a long time, and I thought, yes, I think if Thomas can be in jail for 23 years, I think I can do something like this in return. But I didn't want Debbie to know about it, and so I called Thomas. I set up a meeting with the DA's office. Craig Watkins is the DA in Dallas, and I set up a time with him, and I met Thomas McGowan on the very top floor of the DA's office in 2009. And I got to tell you, it's probably the second most nervous time in my life as a police officer was talking to Thomas. I was expecting a man full of hate and resentment, just ready to tear into me. And I have to say right now that Thomas McGowan is my hero. He was very humble. He's a very forgiving man. And the first thing we did was we hugged, and he said, Mike, I don't hold anything against you at all. And it was this big weight lifted off of my shoulder, and I won't say that we're best buddy drinking friends right now or anything like that, but we are good friends, and we had a good meeting that day. And so after that, I felt good about Thomas, and I didn't think he was going to try to take advantage of the situation or do any harm to Debbie. So the next step was telling Debbie, and I did. And I said, are you interested in this? And being the person that she is, she said, it's tough on me. And this is even after a year's worth of an additional counseling that she was going through. It was a very tough time for her. Well, we went and met with Thomas. Debbie and I did. And it was one of the most emotional things I've ever been through in my life. We all hugged and cried and talked and decided that we could make amends and we could make things better. And so we did. And unbelievably, like I said, I would never guess this in a million jillion years that I would do this, that here I am, I'm standing on the stage in front of 500 police chiefs in Denver, Colorado, about to give a presentation with a guy that just spent 23 years in prison for a case that I worked, and the victim is there too. And I guess I want to end that story by saying is that keep your mind open. You never know. I never dreamed that would happen. I never dreamed that I could be up on the stage like that. I never dreamed that I could be talking to this man that I knew hated me to the core. He told me so in his letters. Now, I text him every Thanksgiving and wish him happy Thanksgiving and Merry Christmas. He does the same thing back to me. Since then, we've probably had a half a dozen speaking engagements, and we always get along very fine. So I guess the point of my story with Thomas and Debbie is to keep an open mind in anything that can happen. I want to close the page on that story right now and end my segment with a couple of points with you. What I just said is please keep an open mind. If you do that, don't be in a box. I don't think you have to be crazy about the things that you want to do, but just keep an open mind. Like I said, a lot of the things that happened in this case and that's happened the last couple of years, I would never have thought have happened. I ended up on a panel just 2 months ago in Washington, D.C., and I'm sitting next to Barry Scheck. And he was, if you remember, he was the lawyer for O.J. Simpson in his trial, and he's the head of the Innocence Project for the United States. And I would have never in a million years thought I would be sitting on a panel with him, and by the end of the day, we were calling each other by our first names. And a couple other things is I want to emphasize the importance of education, especially on our science. DNA is a godsend to us. It's a golden egg, and we must make sure that we do the right procedures, take care of our laboratories the way that we should, keep them funded, because this is something that we've got to have, and if we abuse it, we will lose it, like a lot of other things. So we need to make sure that we take care of that and use also the technology that we have today, the new procedures, the communications that we have. There's no reason for us not to be up to date on that. I also want to emphasize that we're all part of the team. We can't say it's just the prosecutor. We can't just say it's the police, the jury, the judges threw that out. We're all on the same team. And it makes no sense. It causes no positive thing at all for us to point fingers at each other. And so what we need to do is, this is what I want to end on. I want us all to think that we're all part of the team, that it's not us and them. You know, the prosecutor and the police officer are the same, and we're working together. The judges are all the same. It's not we're trying for the conviction. That's not what we're trying for anymore. We're trying for what's right. We're trying for justice and do what's right. And with that said, I want to introduce the Chief of Austin, Chief Art Acevedo, and he will do the next segment for us.
Thank you, Mike, for that testimonial. I'm the Chief of Police in Austin, and I'd really like to talk to you officers today about the importance of education to the success of your careers. Most of us think of tactical training as being key, but in order to bring justice to the victims of crime and criminals to justice, it's important we know the rules of engagement and the rules by which our actions will be judged. With Mike's story in mind, I will now explain to you the Brady Law, or the law that governs the disclosure of favorable evidence in criminal cases. It all began with the 1963 case of Brady versus Maryland, when the Supreme Court held that the suppression by the prosecution of evidence favorable to an accused violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. But let me back up just 1 minute before we discuss Brady. Pursuant to Article 39.14 of the Texas Code of Criminal Procedure, offense reports and investigative reports prepared by the police are protected from discovery as work product of the police. However, the privilege derived from the work product doctrine is not absolute, and the duty to reveal material exculpatory evidence as dictated by Brady overrides the work product privilege. So under Brady and his progeny, a defendant must show three things to establish a Brady claim. First, the state failed to disclose evidence. Secondly, the withheld evidence is favorable to him or her. And thirdly, the evidence is material. That is, that a reasonable probability exists that had the evidence been disclosed, the outcome of the trial would have been different. Okay, let's break this down, starting with the first prong, the state's failure to disclose evidence. A couple of things to keep in mind here. First, Brady applies whether the failure to disclose was intentional or simply a mistake. Second, the duty to disclose extends to all members of the prosecution team. And as much as we like to joke about attorneys, we are part of that prosecution team as investigators and police officers and part of the state. The state includes, in addition to the prosecutor, other lawyers and employees in his office and members of law enforcement and crime lab personnel connected to the investigation and prosecution of the case. There are no distinctions drawn between different agencies. That means that you are part of the state. The state's duty to disclose evidence is a continuing duty, and it attaches as soon as that evidence comes into the hands of the state, whether that is during the investigation, at trial, or years later, for example, DNA evidence. Now let's turn to the second prong of Brady, that the withheld evidence is favorable to the accused. I want to point out that the term favorable has been applied very broadly in the context of Brady. Favorable evidence is defined as that which, if disclosed and used effectively, may make the difference between conviction and acquittal. Favorable evidence encompasses a great deal of evidence because it includes both exculpatory evidence and impeachment evidence. Exculpatory evidence is that which may justify, excuse, or clear the defendant from fault. And impeachment evidence is that which disputes, denies, or contradicts other evidence. If you have any question at all whether the evidence may be favorable, just assume that it is and hand it over. And so we reach the third prong, that the evidence is material to guilt or innocence. On appeal, this often becomes the key focus in a Brady analysis. The defendant must show that, in light of all the evidence, it is reasonably probable that the outcome of the trial would have been different had the prosecutor made a timely disclosure. A reasonable probability of a different result is shown when the government's evidence suppression undermines confidence in the outcome of the trial. It is important to note that the determination of whether evidence is material is a question for appellate courts, not law enforcement, not lab personnel, not even the attorneys trying the cases. This is because the significance of any piece of evidence cannot be fully comprehended unless it is analyzed in the context of the entire trial record. When appellate courts evaluate whether the materiality standard is satisfied, they balance the strength of all the exculpatory evidence, or that which is helpful to the defense, against all the evidence supporting conviction. I want to reiterate that, in part because of materiality is a question for appellate courts alone. If you have any question at all about whether to disclose evidence, hand it over. Now that I've set forth the basic law under Brady, let me give you a few examples that illustrate how Brady has applied to real cases. It helps to put into context the law. Of course, the first case is Brady versus Maryland, the seminal case here in which the basic rule of disclosure was set forth by the United States Supreme Court. In that case, the defendant, Brady, was convicted of murder committed during a robbery. Brady admitted participating in that murder, but he claimed that his companion did the actual killing. Prior to trial, defense counsel had requested review of the co-defendant's statements, but it was not until after Brady's conviction and sentencing that he discovered that one particular statement, one containing the co-defendant's admission of the actual killing, had not been revealed to the defense counsel. The Supreme Court determined that the prosecution's suppression of this evidence, which was clearly favorable to Brady, violated due process. Withholding the co-defendant's confession was prejudicial to Brady, and a new punishment trial was necessary. The Supreme Court explained that a prosecution withholds evidence on demand of an accused, which, if made available, would tend to exculpate him or reduce the penalty, help shape a trial that bears heavily on the defendant. That casts the prosecutor in the role of an architect of a proceeding that does not comport with standards of justice, even though, as in the present case, his action is not the result of guile, to use the words of the Court of Appeals. For years after the basic rule in Brady was set forth, there was some confusion as to the meaning of material. So in 1985, the Supreme Court explicitly identified that proper standard. In United States v. Bagley, the defendant, Bagley, was charged with violations of federal narcotics and firearm laws. Despite his timely filed discovery motion asking whether the state's witnesses received any deals, promises, or inducements in exchange for their testimony, the state failed to disclose any such information. Nevertheless, following his conviction, Bagley learned that several witnesses were in fact paid. On appeal, Bagley argued that failure to disclose this information violated his right to due process, citing Brady. The opinions of the lower courts reflected the general confusion regarding the appropriate materiality standard to apply to a Brady claim, so the Supreme Court stepped in. After emphasizing that both exculpatory and impeachment evidence fall under the Brady requirement, the Supreme Court articulated the materiality standard that we discussed earlier. The defendant must show that there is a reasonable probability that the information would have been material to the determination of the defendant's guilt or punishment. That is, the evidence is material when it affects a defendant's right to a fair trial. This standard is critically important for appellate courts. Another significant Supreme Court opinion was handed down in 1995 in Kiles v. Whitley. In that case, a woman was accosted by a man outside of a grocery store, and after a short struggle, the suspect drew a revolver and fired into the victim's temple. Kiles was later arrested for the offense, and he was convicted of first-degree murder and sentenced to death. Subsequently, however, it was revealed that the state had not disclosed favorable evidence about the crime. This included statements from two key eyewitnesses at the crime scene. One key eyewitness later testified that he had seen the actual shooting by Kiles. However, unbeknownst to the defense, that eyewitness had informed police that the assailant was about 5'4" or 5'5", 140 to 150 pounds, medium build, which contrasted with Kiles' 6 feet tall and thin frame. Another critical eyewitness testified that Kiles was the assailant and that he saw Kiles struggle with the victim. But undisclosed statements taken at the crime scene were vastly different. The eyewitness had not seen the actual murder and had not seen the assailant outside the vehicle. The Supreme Court found that the suppressed statements made to the police contained significant inconsistencies and self-incriminated statements by the witnesses. The courts further stated that disclosure would have raised opportunities for the defense to attack the thoroughness and even the good faith of the investigation, and would also have allowed the defense to question the probative value of certain crucial physical evidence. Other undisclosed evidence included favorable statements made by an informant who had never testified, and a computer printout of cars parked at the scene on the night of the crime did not list Kiles' car. Kiles filed for federal habeas relief, citing Brady and claiming his 14th Amendment right to due process was violated because the suppressed evidence was both favorable and material to his guilt and punishment. The Supreme Court granted relief and ordered a new trial. The Supreme Court determined that disclosing these statements would not have only weakened the prosecution's case, but also substantially reduced the value and credibility of the state's two best witnesses, particularly because the evidence would have revealed significant inconsistencies. While the information may not have proved Kiles innocent, it was reasonably probable that the net effect of it could have produced a different result at trial. An important takeaway from this case: although a single piece of the information alone may not meet the Brady materiality standard, the cumulative effect of evidence did here, so it should be disclosed. In Texas, we have had our own fair share of Brady cases. One such example occurred in the case of Ex parte Richardson, which was decided in 2002. Richardson and 3 others were indicted for capital murder. Richardson stood trial first, and the state's only eyewitness provided testimony that placed Richardson at the murder scene during the time of the killings and assigned primary responsibility to him. Richardson was found guilty and sentenced to death. However, the co-defendants were acquitted because in subsequent trials, the eyewitnesses' stories completely unraveled. On appeal, Richardson argued the state failed to disclose the existence of a diary by a former police officer, which would have provided him with powerful impeachment evidence against the witness. The police officer had served on the eyewitness's security detail, and the officer testified that she maintained the diary of the time spent guarding the eyewitness because she believed the witness was not a truthful person and hoped to protect herself from false accusations. Richardson claimed that there was a reasonable probability that the jury would not have convicted him if he had been able to properly cross-examine the witness. The Texas Court of Criminal Appeals agreed. It held that the state had an affirmative duty to disclose this evidence that impeached the eyewitness testimony and that the evidence would have likely undermined the confidence in the outcome of the proceeding. Just last year, the Texas Court of Criminal Appeals found a Brady violation in ex parte Richard Ray Miles. In that case, the applicant filed applications for writ of habeas corpus claiming, among other issues, that the state violated Brady when it failed to disclose 2 police reports that identified other potential suspects for the shooting. The Court of Criminal Appeals agreed that Miles was entitled to a new trial on Brady grounds because the information contained favorable evidence material to his case, and the state failed to disclose such evidence. The reports may have been exculpatory because they identified other potential suspects for the crime, and the reports may have been used to impeach trial testimony that there were no other suspects in the case. The undisclosed evidence could have also led to additional exculpatory or impeachment evidence. The Court of Criminal Appeals specifically found that, even if the prosecution was not personally aware of the evidence, the state is not relieved of its duty to disclose because the state includes, in addition to the prosecution, other lawyers and employees in his office and members of law enforcement connected to the investigation and prosecution of the case. Because Dallas PD had possession of the reports, the state was responsible for their disclosure. However, those reports were not present in the state's file, nor were they produced pursuant to defense counsel's pretrial request for production or previous other requests on applicants' behalf. It was not until the records were obtained from the DPD via one final request that the applicant became aware of the documents. I hope this discussion has given you a basic understanding of the requirements provided by Brady and its progeny. For me, the key is to not get too wrapped up in the analysis. If you have any question about the evidence, turn it over because it might make the difference once all of the evidence comes together. Now let's talk about a law called the Michael Morton Act. It became effective January 1st, 2014, and it affects discovery in criminal cases in Texas. Because this law was so new at the time of filming, the courts have yet to interpret it, so we don't know what the courts will say about it. Therefore, our discussion will be limited to the actual text of the law, which we will give to you in small pieces. With that qualification, let's dig into the Michael Morton Act so you know the basics of this important new law. The request. The law begins, subject to the restrictions provided by Section 264.408 Family Code and Article 39.15 of this code, as soon as practical after receiving a timely request from the defendant. Production and inspection. The state shall produce and permit the inspection and the electronic duplication, copying, and photographing by or on behalf of the defendant of any offense reports, any designated documents, papers, written or recorded statements of the defendant or a witness, including witness statements of law enforcement officers, but not including the work product of counsel for the state in the case and their investigators and their notes or report, or any designated books, accounts, letters, photographs, or objects or other tangible things not otherwise privileged that constitute or contain evidence material to any matter involved in the action and that are in the possession, custody, or control of the state or any person under contract with the state. Electronic copies allowed unless defendant is pro se. The state may provide to the defendant electronic duplicates of any documents or other information described by this article. Work product doctrine. The rights granted to the defendant under this article do not extend to written communications between the state and an agent, representative, or employee of the state. State's right to possess the evidence. This article does not authorize the removal of the documents, items, or information from the possession of the state, and any inspection shall be in the presence of a representative of the state. Expert testimony notice. On motion of a party and on notice to the other parties, the court in which an action is pending may order one or more of the other parties to disclose to the party making the motion the name and address of each person the other party may use at trial to present evidence. Under Rules 702, 703, and 705 of the Texas Rules of Evidence, the court shall specify in the order the time and manner in which the other party must make the disclosure to the moving party, but in specifying the time in which the other party shall make the disclosure, the court shall require the other party to make the disclosure not later than the 20th day before the date the trial begins. Redaction allowed. If only a portion of the applicable document, item, or information is subject to discovery under this article, the state is not required to produce or permit the inspection of the remaining portion that is not subject to discovery and may withhold or redact that portion. The state shall inform the defendant that a portion of the document, item, or information has been withheld or redacted. On request of the defendant, the court shall conduct a hearing to determine whether withholding or redaction is justified under this article or other law. When a person represents themselves pro se, in the case of a pro se defendant, if the court orders the state to produce and permit inspection of a document, item, or other information under this subsection, the state shall permit the pro se defendant to inspect and review the document, item, or information, but is not required to allow electronic duplication as described by subsection A. Disclosure of discovery to third party. Except as provided by subsection F, the defendant, the attorney representing the defendant, or an investigator, expert, consulting legal counsel, or other agent of the attorney representing the defendant may not disclose to a third party any documents, evidence, materials, or witness statements received from the state under this article unless 1. A court orders the disclosure upon a showing of good cause after notice and hearing after considering the security and privacy interests of any victim or witness, or 2. The documents, evidence, materials, or witness statements have already been publicly disclosed. Duties of defense attorney. The attorney representing the defendant or an investigator, expert, consulting legal counsel, or agent for the attorney representing the defendant may allow a defendant, witness, or prospective witness to view the information provided under this article, but may not allow the person to have copies of the information provided other than a copy of the witness's own statement. Before allowing that person to view a document or the witness statement of another under this subsection, the person possessing the information shall redact the address, telephone number, driver's license number, social security number, date of birth, and any bank account or other identifying numbers contained in the document or witness statement. For purposes of this section, the defendant may not be the agent for the attorney representing the defendant. Rights of defense attorney. Nothing in this section shall be interpreted to limit an attorney's ability to communicate regarding his or her case within the Texas disciplinary rules of professional conduct, except for the communication of information identifying any victim or witness, including name, except as provided in subsection E and F, address, telephone number, driver's license number, social security number, date of birth, and bank account information, or any information that by reference would make it possible to identify a victim or a witness. Nothing in this subsection shall prohibit the disclosure of identifying information to an administrative, law enforcement, regulatory, or licensing agency for the purposes of making a good faith complaint. Brady material. Notwithstanding any other provision of this article, the state shall disclose to the defendant any exculpatory, impeachment, or mitigating document, item, or information in the possession, custody, or control of the state that tends to negate the guilt of the defendant or would tend to reduce the punishment for the offense charged. Record of discovery. The state shall electronically record or otherwise document any document, item, or other information provided to the defendant under this article. Certification of discovery. Before accepting a plea of guilty or nolo contendere, or before trial, each party shall acknowledge in writing or on the record in open court the disclosure, receipt, and list of all documents, items, and information provided to the defendant under this article. The state's duty to disclose applies before, during, and after trial. If at any time before, during, or after trial, the state discovers any additional document, item, or information required to be disclosed under subsection H, the state shall promptly disclose the existence of the document, item, or information to the defendant or the court. Cost of evidence production. A court may order the defendant to pay costs related to the discovery under this article, provided the cost may not exceed the charges prescribed by subchapter F, Chapter 552, Government Code. If a request under the Michael Morton Act and an open records request conflict, the Act prevails. To the extent of any conflict, this article prevails over Chapter 552, Government Code. Parties may agree on discovery. This article does not prohibit the parties from agreeing to discovery and documentation requirements equal to or greater than those required under this article. The Michael Morton Act is broader than Brady, meaning that material not covered by Brady may be covered by the Michael Morton Act. The Michael Morton Act has not yet been interpreted by the courts, so we don't know exactly what it means, but it is important to be aware of it. So let's recap the essential and important lessons we have learned today. Pursuant to Article 3914 of the Texas Code of Criminal Procedure, offense reports and investigative reports prepared by the police are protected from discovery as work product of the police. However, the privilege derived from the work product doctrine is not absolute, and the duty to reveal material exculpatory evidence as dictated by Brady overrides the work product privilege. Knowledge of possession of exculpatory evidence by the state will be imputed to prosecutors through state agents. The individual prosecutor has a duty to learn of favorable evidence known to others acting on the government's behalf in a case, including the police. Favorable evidence is that which, if disclosed and used effectively, may make the difference between conviction and acquittal. Favorable evidence may constitute either exculpatory or impeachment evidence. Exculpatory evidence is evidence which tends to justify, excuse, or clear the defendant from alleged fault or guilt. Impeachment evidence is evidence offered to disparage, excuse, or clear the defendant from alleged fault or guilt. Evidence is material if there is a reasonable probability that, had the evidence been disclosed to the defense, the outcome of the proceeding would have been different. In other words, the question is whether the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine the confidence in the verdict. A reasonable probability is a probability sufficient to undermine confidence in the outcome of the trial. There is no good faith exception to duty to disclose. The duty to disclose material favorable evidence continues post-conviction. Due process requires reversal if the state, regardless of whether the defense made a request, failed to disclose favorable evidence to the defense. To further our understanding, I'm going to turn it back over to Chief James McLaughlin so that he can work through some real-life hypothetical situations with you.
Thanks, Chief. Of course, it is very important to know the law itself, but we need to apply those concepts to facts in order to get a truer understanding of the constitutional obligations with which we are faced. Of course, feel free to pause the video to give yourself some time to reflect upon these scenarios and perhaps discuss them with colleagues. We'll start with scenario number one. During a murder investigation, you interview a witness that claims to have seen the victim alive. Very late within the window of time, the medical examiner estimates the victim was killed, and during a time when the chief suspect has a questionable alibi. nor the witness claims to have seen the victim so late in the day, and the witness is simply likely to have gotten the time wrong. It is possible, but not likely, the witness is accurate about the time. Is this a Brady issue? Yes, this information should be disclosed under Brady. This information is certainly favorable to the accused. The evidence is exculpatory because it tends to clear the defendant from alleged fault or guilt. The witness's observations, as they relate to the time of the events, suggest the suspect might not be responsible for the murder. That is, the alleged sighting of the still alive victim would narrow down the estimated time of death, and the suspect provided an alibi, although questionable. It is also possible that this particular evidence could be used to impeach or question the testimony of other witnesses regarding the timing of their own observations. I want to point out that this scenario is couched in the terms of unlikely or dubious, but that does not change your duty to disclose, because it is not for us to judge the strength or weaknesses of favorable evidence in the context of the case. Even non-credible evidence is Brady evidence. And the question comes, who do you disclose this evidence to? Well, as law enforcement officers, it would be to the state prosecution. I would suggest also that you make a good record of what you have disclosed and who to. Scenario number 2. Based on a description provided by a purported eyewitness, investigators initially focus on one suspect. Further investigation indicates that the supposed witness could not have seen what he claims, and an alternative suspect is eventually pursued and indicted. Is the fact that there was once another suspect in a crime a Brady issue, even though the suspect was developed on faulty evidence? Answer: yes. The fact that there was once another suspect in the crime is definitely Brady evidence and should be disclosed, even though the suspect was developed on faulty evidence. The existence of another suspect is exculpatory evidence that might excuse or clear the defendant from fault. That is, it might cause the jury to question his guilt. The evidence might also aid in his defense. The scenario is loosely based on the case discussed earlier, Ex parte Miles. In Miles, the state had emphasized the absence of any other suspect in its arguments and questioning at trial. But the Brady evidence, the 2 undisclosed police reports, identified other potential suspects. The Texas Court of Criminal Appeals determined that the evidence would have allowed the defendant to dispute the state's position. It could have made the difference between a conviction and acquittal. Scenario 3. The defendant murdered 2 individuals, and he claims he committed the killing while suffering from acute psychosis caused by drug addiction. You come across several notations in the defendant's medical records indicating that he might have been experiencing drug withdrawal psychosis at the time of the crime. Should this be disclosed under Brady? Answer: yes. This should be disclosed. This is Brady evidence. The records could corroborate the defendant's defense and bolster his case in the mitigation of the death penalty. Let's change the previous scenario a bit. Same defensive theory, but what if instead of statements in the medical records, evidence of the defendant's possible mental illness was simply observed by jailers? Answer: yes, even though the jailer's observations are not medical diagnosis. They may nonetheless support the defendant's insanity defense and bolster his case in the mitigation of the death penalty. It does not matter how official or believable evidence may be. If there is a chance it could aid in the defendant's defense, turn it over. These 2 related scenarios are derived from Cone v. Bell, a case out of the United States Supreme Court. In that case, the defendant was tried for the murder of 2 people. The sole defense offered was that at the time of the murders, the defendant suffered from acute psychosis caused by drug addiction. But the prosecution argued that the defendant was a drug dealer rather than a drug user. Years later, the defendant discovered through public records requests that there were materials in the prosecution file that had not been disclosed. The withheld documents were statements from witnesses who had seen the defendant several days before and several days after the murders and described his bizarre appearance and behavior. There was also a police report describing the defendant's bizarre behavior. Although the Supreme Court remanded On another issue, it held that the suppressed evidence was indeed favorable because it supported the defendant's claim of habitual and excessive drug use. Scenario number 4. You discover that a witness statement, one of 5 the witness provided, was mistakenly left out of the file sent to the district attorney. The statement differs in some significant details from the other 4, but trial has already started and the witness may have already testified. Need you bother? Answer is yes. The duty to reveal favorable evidence to the defense attaches when the information comes into the state's possession, and this duty should be acted upon as soon as possible. The undisclosed statement is classic impeachment evidence, so you should notify the district attorney as soon as possible of the evidence. It doesn't matter that the trial is in progress. The same would be true if the trial has already been completed. When you discovered that the statement was left out of the file, your duty under Brady is a continuous duty that continues after conviction. So even if years have passed, disclose the evidence to the prosecution. Scenario number 5. You have heard that an important state witness may have successfully completed a probation term for a felony. You purposely do not run a criminal record check. Is this acceptable? Answer, no. Run the background check. Impeachment evidence is considered favorable to the accused and is therefore subject to the mandatory disclosure dictates of Brady. Certainly, a criminal background would be grounds upon which to impeach the state's witness. It could undermine the jury's appreciation for the witness's testimony. Although you do not have any specific duty to run the check, if you don't run it, and it turns out this evidence was out there is a serious risk that the case will be reversed. Scenario number 6. Similar idea to the last scenario, but in this case you run a check on the complainant and discover she has a pending arrest warrant. Is this a Brady issue? Yes, Brady attaches here. Just like the previous scenario, this is classic impeachment evidence. And since the complainant's credibility is at issue, this impeachment evidence may well make the difference between guilt and acquittal. In Johnson v. State, out of Fort Worth, it was not disclosed to the defense that there was an outstanding arrest warrant on the complainant. The Fort Worth Court of Appeal emphasized a defendant is entitled to evidence that may impeach the credibility of a state witness, and where this witness' credibility is material to the disposition of the defendant's guilt, the prosecutor's failure to disclose such evidence violates Brady. Scenario number 7. You are aware that a witness who will testify in punishment about an extraneous offense was once a paid police informant. Again, the question, is this a Brady issue? The answer is yes. This information should be disclosed because it may serve as a basis for impeaching the informant's credibility and perhaps even the substance of his testimony. Please note it does not matter that the informant's testimony is relevant only to punishment and not to guilt, as the duty to disclose applies in both phases of trial. Also, even though the testimony relates to an extraneous offense, it is not for us to judge the evidence. Just go ahead and turn the impeachment evidence over. Scenario number 8. The sole surviving witness to a gang shootout claims at the scene, where there may still be many gang members, that he did not recognize the shooters. Later, along with law enforcement agency, he quickly provides a description and street names of the gunman. The defendant is arrested and charged with murder. There is no physical evidence linking him to the scene. Is the witness crime scene statement Brady evidence? Yes, this is a situation that the Supreme Court was presented with just last year. In Smith v. Kane, the defendant was convicted of killing 5 people during an armed robbery. At trial, the single witness identified the defendant as the first gunman to come through the door. No other witnesses and no physical evidence implicated the defendant in the crime. Post-conviction, the defendant obtained a detective's notes, which contained statements by the sole witness that conflicted with his testimony identifying the defendant as the perpetrator. These notes stated that the witness could not supply a description of the perpetrator or identify anyone because he could not see the face. The Supreme Court determined that the witness's undisclosed statements alone sufficed to undermine the confidence in the conviction because the witness' testimony was the only evidence linking the inmate to the crime. and the witness's undisclosed statements directly contradicted the witness's testimony. Scenario number 9. A witness reveals to you that he has been promised a deal by one of the detectives who interviewed him. While discussing the case with the prosecutor, you discover that the prosecutor knows nothing about the promised deal. Should this be disclosed under Brady? Answer is yes. The reliability of a given witness may be well determinative, so Brady requires the disclosure of any impeachment evidence, including the existence of possible deals between the witness and the state. Additionally, it is critical to recognize that even if the prosecutor is not personally aware of the evidence at issue, the state is not relieved of its duty to disclose. The prosecutor is responsible for all members of the prosecution team, which includes attorneys, law enforcement, crime lab technicians, and others working on the case. No distinction is drawn between different agencies under the same government. Scenario number 10. While doing a background check on a witness, you run the name she has provided, but don't bother to check any obvious possible aliases. Brady violation? Potentially. So why risk it? Although whether or not the information and material can only be evaluated on appeal, it could be a Brady violation not to check out any obvious possible aliases. You have an affirmative duty to disclose impeachment evidence, including criminal backgrounds. This is especially true when you possess the information in your own records. So go ahead and search under similar names and the witness's date of birth. Remember, it's not for us to judge, so it's better to go ahead, run the check, than regret not doing it later. Scenario 11. An employee of a gentleman's club reveals to you that another officer has asked 2 of the employees for dates and was rejected by both. You find it hard to believe since you know the officer personally, and it does not seem at all in character. One of the girls is later arrested for DWI by the officer. Is this Brady? This one is just food for thought. Thank you so much for partaking in this training video. As a reminder, T-Close credit is available for this presentation. The course number is 21000. Finally, if you have any questions, please contact Judge Barbara Hervey at 512-463-1575. Thank you.